Ramesh Prabhu sir to start with the session. Mr. Prabhu is highly qualified CA for last 22 years. He is partner in many CA firms and esteemed director of Prabhu Associates Consultant Private Limited. He is a regular faculty with ICAI and has authored various books on different issues of society. Mr. Prabhu has been specially invited by Maharashtra government in making the draft regulation of RERA. Before he starts, once again, I would everyone like to applaud for him. Come on. We're really happy to have you, sir. Can we start with the seminar?
Good evening, friends. At the outset, let me congratulate Nimisha Gupta for coming out the quarterly Realty and Realty Quarter, QR. So congratulate you. And now let us, you're all comfortable in English or Hindi? Which is the better language? English is comfortable. Okay. So let me start with the straight away presentation. What we have done is we have divided the entire 10 chapters into two parts. The initial 4 chapters, that is starting with the preliminary and up to the obligations and rights of the allottees. And of course, obligations of the promoter, registration, all that will be taken by me. And the rest of the 6 chapters, which is related to the what is known as our dispute redressal, real estate regulatory authority, real estate tribunal, adjudicating officer, offences and penalties, and various judicial pronouncements will be taken by Devang Mehta. So with this, some changes in the agenda, we'll proceed. Now to start with, yes, why this has come, I think we don't require any explanation. Anything which is always done excess, the nature takes care. If we don't take the decisions, then somebody else has to take the decision. So naturally the community which was doing this sector, which were supposed to self-regulate, but the people who are entering into this sector has made the life of the consumers miserable. So naturally the government was compelled to come out with the regulations of the real estate sector. So I don't think I need to speak all this, which you are all aware. Basically, what was not supposed to be done by a businessman, where crores of rupees is taken of hard-earned money of the consumers, and in order to see that the sector gets properly regulated, this sector has come. Now this is the law of the land. From 1st May 2017, this is effective across India. Of course, we know that it is ultimately governed or to be regulated by the respective state government, and state government has its own priorities, and therefore some of the states, barring hardly 15 or 20 states, rest of the states have not even notified the draft rules for the purpose of implementation. Hardly 5 to 6 states must have done the regulator, and Maharashtra is leading. And on the day 1, we have what is known as online registration of real estate project. Everything is coming online. Of course, even we are lacking. We do not have right now Appellate Tribunal. Last month only adjudicating officer has been appointed. So from 1st of May 2017, registration process has started. Now if you have to take out the journey, yes, the act was initially with few sections implemented on 1st May 2016, giving necessary scope for the state government to come out with the rules within 6 months. Thereafter, the setting up of a regulatory authority, and thinking that by 1st of May 2017, the law should become fully operational. Of course, Maharashtra government has made the law fully operational. There is a required rules, there is a required regulations, and the regulatory authority is also sitting. If you have to look at this, the word regulator, if you look at the last, the central government and state government to notify the rules in 6 months and establish the real estate regulatory authority and appellate tribunal within 1 year. As far as Maharashtra is concerned, still Appellate Tribunal is not set up. It is in the process of making the Appellate Tribunal. Now, let us come to the regulator. Yes, the regulator is for the purpose of registration of a real estate project. This is for the purpose of registration of a real estate agent, both the prominent people. Then the function is to monitor, supervise, redress the dispute, control, protect all the stakeholders. It is not that only the consumers are protected, even the developers, if they are required to take some recourse against the consumers, they can take. So the law is not retrospective. That is very, very important to understand. The law is not retrospective, it is a prospective. Now the moment I say that it is not a retrospective, the question arises, then what will happen to ongoing project? So therefore, every state government is required to define what is ongoing project. But the law is very clear as far as when we look at the section 3, the ongoing project is one where there is no occupation certificate. Because as far as the development control rule is concerned, when the building is been approved, unless until that building gets the occupation certificate, the building is not complete in all respect. So only after the occupation certificate is issued or a completion certificate is issued, we can say that the building is complete in all respect. So considering that in mind, as far as all the buildings which do not have the OC require registration because they are ongoing project. Now next is, the question arises, it is applicable to all ongoing projects and new projects, commercial, residential and plotting. See, the word itself indicates it is known as Real Estate Regulation and Development Act. Now, if I have to look at the Real Estate Regulation and Development Act, the question arises where it is applicable. Naturally, it is applicable across India. So, the law is applicable across India. If you have to look at the comparison of Maharashtra Ownership Flat Act 1963 and Real Estate Regulation and Development Act 2016, the major difference is it is applicable across India. Secondly, it is related to owning and acquiring of the rights. When we talk about owning and acquiring of the rights, you can acquire any immovable property rights, even leasehold rights. So therefore, under the Transfer of Property Act, even the lease rights are covered. So therefore, it is not only covering the freehold rights, it is also covering the leasehold rights. If there is something property which is given on the lease, including the housing which is given on a lease where you recover the lot of premiums and the project which is undergoing or ongoing, naturally they are covered. The next is, if you look at MOFA, it was only talking of Maharashtra Ownership Flat Act. So lease was almost, it was not applicable. Whereas in the Real Estate Regulation and Development Act, lease is covered. The third comes, as far as Maharashtra Ownership Flat Act was concerned, it was talking about flat. It was talking about flat means constructed area. When we talk about flat, it is talking about self-contained units, which could be commercial, residential or anything. Whereas in the case of real estate, as the word indicates, again it is covering plotting also. It is not only flats, even the plots which is getting developed and which is being sold in the market with the common amenities or without common amenities, maybe there will be a common area, there may be common garden. So whatever it is, it will be covered. Now the question arises, if it is applicable across India, how it will be implemented? Naturally, because land is a state subject and moreover, this real estate subject as such is being a special contract, falls under the what is known as concurrent list. In the Constitution of India, the law could be made by the central government or by the state government. If the law is made by the central government, naturally the law of the central government will prevail. The state government's law will not be, to that extent, will not be applicable. So therefore, what the law provides, that appropriate government will make appropriate rules. When we talk about appropriate government, as far as wherever there is a state government, it will be state government. In the case of central government, as far as union territory is concerned, it will be central government. So naturally, the state governments are required to make a respective rules, and then they are required to make a respective regulatory authority, appellate tribunal, adjudicating officer, and set up the required mechanism or the system process to implement this law. So that is how the implementation will take place.
The word used in Real Estate Regulation and Development Act is the apartment. It is not talking about flat. It is talking about apartment. Now, when we talk about apartment, what could be the apartment? Apartment could be a flat, shop, garage, bungalow, industrial, office, developer plot. Well, a lot of questions were raised. When we talk about apartment, it does not cover what is known as industrial. It is wrong. Even the industrial sectors are covered because ultimately that is getting developed. So if you look at the real estate project, when we look at a real estate project, it talks about all type of development. So therefore, any constructed or to be constructed, including the plotting, is covered under RERA. Then the next question arises about the stakeholders. I said all the stakeholders are covered, and as far as RERA is concerned, we have basically three stakeholders which has been designated. One is related to promoter, second is related to the allottee, and the third is the service providers. Now, when we talk about, because word service provider was never ever included in MOFA, Maharashtra Ownership Flat Act, which of course respective states were have, but there was no question of service providers who are made accountable, responsible, and the disclosure of that was made. But in the case of Real Estate Regulation and Development Act, RERA, we have a promoter who is also considered to be the person who is responsible to develop the project and responsible to and make accountable to develop the real estate project. Now, in the MOFA, I am always trying to refer MOFA, which was the earlier law, where promoter means one who constructs, of course, was causing to construct, but that was not further expanded to include the landowner who is receiving the area sharing or who is receiving certain share in the sales, which is known as revenue sharing. That was not included. But now the promoter is also including the landowner who causes the construction and who receives certain flats for the purpose of sale. So they are called as a co-promoter. Therefore, in the case of a housing society, which is one of the agenda item, so whether they are considered as a co-promoter, answer is yes. If a housing society is going for a redevelopment and they are allowing a developer to construct the building, and thereafter from those sale proceeds which has been sold, from that sale proceeds a new house will be constructed, and that area is given free of cost to the existing society so that the existing society can distribute to their members. So which means they considered as a revenue sharing in kind. So it is not revenue sharing or it is not an area sharing where the society sells to the consumers, but it receives the promoter receives the revenue, and from that revenue he constructs the building, and thereafter certain area, maybe as agreed in the development agreement, will be given to the society, and therefore the society becomes the co-promoter as far as revenue sharing is concerned. Of course, revenue sharing in kind. Now, again, the word promoter is further expanded as far as RERA is concerned. How it is expanded? It includes the government. If the government is coming out with any scheme of affordable housing, giving a housing where they are going to charge certain amount, it could be a concessional amount, still they are allotting the house, allotting the plot, and therefore they are required to register under RERA and they become a promoter, including local bodies, government bodies, public authorities, anybody and everybody. To that extent, even affects cooperative finance society, which is giving a housing finance for its members to buy the house, and they are also considered as a promoter. Further, a primary housing society, let us say they are not going for redevelopment, but 10 of us come together, buy a land, and then we go for formation of a housing society, and we allot the flats to ourselves. Still that housing society, being a legal entity, is considered as a promoter. So therefore, cooperative society, whether it is registered under Multi-State Cooperative Society Act or under the Maharashtra Cooperative Society Act, still they are considered as the promoter, or any other association of persons are promoters. The next arises the allottee. When we talk about the allottee means the flat purchaser. And the flat purchaser, as far as MOFA is concerned, the flat purchaser, apartment purchaser were considered as the flat purchaser, or they are required to enter into an agreement, and they were protected under the MOFA. But in the case of allotee, even the flats which are allotted to the existing slum dwellers under SRA or under the 33.7 or 33.9 or 33.10, whatever we talk about MADA development, or whether it is a cess building development, whether it is a slum redevelopment, whatever the development is happening, even to a housing society where the existing members are given a flat, whether it is by taking consideration or otherwise, they are also considered as allotee. So therefore, the definition of allotee has been expanded, not limited to only flat purchaser. So therefore, instead of calling it as a purchaser or a flat purchaser, we have used, or the RERA has used, the word allotee. Now the third thing, most important, which was not there in MOFA, which has been included, is the service provider. Now when we talk about service provider, we have a real estate service provider. One is the marketing support, that is real estate agent. So therefore, we require to get a registration of a real estate agent. And secondly, that person, once he gets registered, whatever project he is going to sell, those real estate agents are also required to get their name enlisted in the respective projects which are registered by the promoter under the name real estate agent. So this way, real estate agent is required to register twice. One, as a real estate broker, he has to get registered with the RERA. Thereafter, let us say there are 5,000 projects which are there on the website. All 5,000 projects he cannot sell unless until a promoter, a developer enters into an agreement with him and he gives a consent to that real estate agent saying that yes, now you are allowed to sell my project, and their name is uploaded on the website. Thereafter, that broker can sell. So this way, the broker registration takes place at two levels. Next comes all the professionals. Now there is a professional, of course, architect who gets the plan passed. Then we have an engineer who supervises the real estate project. Then we have a chartered accountant who certifies various funding and other arrangements, or the at the time of withdrawal the money what should be done, which of course I will take it little later. But all these professionals who are connected with the real estate projects with their name and the contact details need to be uploaded. So this way, it is not only the promoter and the allotee, it talks about other service providers also. So this is the gadget which you can see. And then if I have to say in one slide what is MOFA and what was missing in MOFA, all the provisions of Maharashtra Ownership Flat Act has been included in RERA. But the RERA is much wider, as we have seen in the beginning, related to promoter, we are related to allotee, related to service provider. So it is much wider scope. But there is a basic difference. And MOFA was lacking only one thing, it was not having its own implementing agency. The MOFA, Maharashtra Ownership Flat Act, was lacking because there was no enforcement mechanism. Everything, if you look at section 3 of MOFA, it was talking about the promoter should disclose all this. Section 4 was talking about that he should enter into an agreement. Section 5 was talking about MOFA, that he has to open an account, he should maintain all the different accounts. Section 10 was talking about forming a society. Section 11 was talking about conveyance, and section 13 was talking about if he does not do all this, then of course it is a criminal offense, the penalty can be levied, he can be prosecuted, everything is there. So everything was supposed to be done by the developer. In spite of that, section 4 was talking about entering into agreement, section 4A was talking about if the agreement is not made, still one can go to the court and get it treated as a evidence in the court of law and then get the remedies. All that was there. It was a wish list. The problem was that if at all there was no proper delivery done by the promoter, that is the builder, then they had to run pillar to post. Some Devang would say, let us go to the consumer court. Another person would say, let us go to the civil court. The third person would say, okay, let us go to the magistrate court because it is a criminal offense. So everybody would take, and last, if you go to the person who is a consumer court specialist, but he is into National Commission, he will say, okay, let us have the, all the flat owners together, it will be more than 1 crore. So we'll go to the class suit in the National Commission. Somebody who is expert in the Competition Commission, he will say, okay, let me take you to the Competition Commission. So that means for a same cause, people would run pillar to post, and the different forums were tried. And ultimately, when we talk about the legal system, with due respect to the legal system, it has to have lot of, time consuming. You have to give the law of natural justice, people have to be called, evidence has to be led. That means it is time consuming. Whereas MoFA was not having its own implementing agency. So therefore, in the RERA, if you look at, the most important aspect of all this is that we are going to have implementing agency. So what is this implementing agency or enforcement agency? In detail, Devang Mehta will definitely tell you. But if I have to tell you the entire objective of MoFA into one slide, it is talking about regulation and it is talking about development. So what is regulation? Regulation, when we talk about regulation, it gives not only the rules which need to be followed, it also talks about when it is to be done, who has to do it, the responsibility and accountability, and if it is not done, what will be the consequences, and thereafter what will be the penalty, and then who will levy the penalty, and thereafter the penalty, how it will be recovered, and how the redressal can, all this is put in the regulation. That is the beauty of the regulation. And next, of course, the RERA also will be talking about development. Because ultimately, the real estate sector has to grow. And if you want to grow it properly, then it has to have a transparency. The moment it has a transparency, the next is it will increase efficiency. Because when you are telling the customer that I am going to give you the position of the flat on so and so date, and this position is going to be coming in 3 years, but I have a stage wise progress. In the first month I will have the IOD, second month I will have a plinth, third month I will have the podium, fourth month I will have first slab done. So like this I have got 36 slabs to be put. I will do in 5 years. So when you are giving a stage wise progress sheet, and if you don't do in it, then the customer has a right to demand explanation, and the customer has a right to go to RERA and check up why the promoter is not complying with what he has been promised and within the time limit. So therefore, the moment you give a transparency, there will be efficiency. And the last is, if there is a transparency, efficiency, of course, development will take place. And the end result is the housing and the project is made for the benefit of the consumer, and ultimately consumers' rights are protected, and whatever money they pay for a particular project is used for that project, and that is how the customers' rights are also protected. Thereafter, to take care of all this, there is a regulatory authority and Appellate Tribunal and of course adjudicating officer, and they will test, verify, give a law of natural justice, and then of course we will have the justice done. So if I have to look at the silent features of the act, the entire act, whatever I have so far discussed, if I have to tell you that yes, real estate project has a registration, because in order to have a transparency, which was not there in MoFA, now the system has been made that real estate project, before selling, before marketing, it has to be registered. So which are the projects to be registered? The new project has to be registered before marketing, selling, advertising any project. This is the first thing. Section 3 talks about all real estate projects before selling has to be registered, before marketing has to be registered. Secondly, ongoing projects, as the time limit has been given, within 3 months from the date of commencement of the act, which is from 1st May 2017, those projects require registration. And if they fail to register the new project and they market, yes, there is a penalty. The penalty is very huge. It can range up to 10% of the cost of the project. When I talk about cost of the project, it includes land cost and construction cost. And this is the estimated cost of the project, which is taken in advance from the promoter at the time of registration. So therefore, If the registration is itself is not done, the estimated cost will be determined by the regulatory authority, and then the penalty will be due. That's a huge penalty. Of course, if the penalty is not paid, how it will be done, Devangji will give you more insight into it. And to register a project, naturally there is a fees involved. And as far as Maharashtra is concerned, real estate regulatory authority has been put online, and therefore we can go to online and register it. And the website address is maharera.mahaonline.gov.in. So if you Google it also, you will get this website. And there is another website which you should not get carried away, maharera.org. That is not an official website. maharera.org also someone has taken a domain, and if you put in Google, that comes as the first site, but that is not an authentic site. Let me warn you. What is authentic site is maharera.mahaonline.gov.in. And in that if you go, then you will see the projects which are listed. Then of course, the second comes any real estate project. Of course, exemptions are there. I will discuss little later. Then we have a real estate agent. Yes, real estate agent also is required to register. And the real estate agent who is registering has to register and sell only the projects where his name is, enlisted. Secondly, he cannot sell the projects which are not registered. Now the question arises, suppose there is a project which is exempted from registration, whether he can do the selling of that? The answer is absolutely no. Even if that is exempted, but he is not authorized to sell a project which is not registered. And therefore there is a controversy, and one judgment which has been passed recently is a case where a Sai Estate Chambur Private Limited, he sold a project or advertised a project which was not registered, though they were exempted from registration till 31st July. Still, because he has sold and he has marketed, he has been levied a penalty of 10,000 rupees per day for 12 days, 1,20,000 has been levied. So therefore, in the real sense, a real estate agent has to sell who is registered, only a registered project. Next, of course, filing of a complaint, which Devang will take. You can file the complaint with the adjudicating officer, real estate regulatory authority, and if you are not happy, of course, Appellate Tribunal. Then we have a financial discipline. As I said earlier, under MOFA, there was no question of filing a complaint. You were required to file a cases. Now, the complaints can be filed with the authority, enforcing authority. Now, there is a financial discipline which is very important. See, the most important we have to look into is that whenever there is a real estate project, the number of developers are not able to deliver what they promise, and one of the reasons is diversifying the fund. A money which has been taken from the customer should be used for that project. Instead of using that project, they take the money from one project, buy the land in another project, from there they will do some booking, they will put into the third project, and they do the over trading, assuming that the market will pick up, and in one of the project, if there is a litigation, all three projects comes to standstill. And that is what has happened in number of cases, and therefore the law provides that any money which has been received from the customer, out of that 70% has to be put in a designated account, which is providing under section 4, and to that effect a promoter at the time of registration has to give a declaration that 70% of the money I will put in a particular designated account, and that money I will use only for the purpose of land cost and construction cost and nothing else. Remaining 30%, yes, I will be using it for the purpose of marketing expenses, maybe paying the brokerage, maybe other overheads, including his salary or anything, and maybe for investing in any other project. But 70% has to be used for that project. Second most important, in the financial discipline, the promoter further has to give a certificate or the undertaking in Form B that he will appoint the project architect who will certify how much percentage of the construction has been completed. The engineer will verify the site and tell how much must be the cost estimated and has been spent on the project. And the third is chartered accountant also will verify from the books of account how much is the actual cost incurred on the project. Whichever is lower will be considered as the towards the land cost and construction cost which is incurred, and to that extent the promoter is allowed to withdraw from that 70% designated account. Once again, any money that comes from the customer will be put in a designated account, and in order to withdraw from that designated account, it should be used only for the land cost and construction cost. And before withdrawing, a promoter need to take a certificate from these three professionals saying that the money before withdrawing has been used for that project, and on the basis of reimbursement that money is allowed to be withdrawn. This way we have a financial discipline. And the last, as I discussed, there is a transparent mechanism, there is a consumer oriented. The next comes, what is the functions? Let us say we have a real estate regulatory authority. Yes, in detail functions, redressal of disputes, Devang will take, Advocate Devang Mehta will deal with it. But to give you in one snapshot, there is an administrative power, administering the entire law and also to implement that law. Then we have a judicial, because there is a quasi-judicial authority, so they can give the ruling, and once the ruling is given, of course, it has to be executed, and therefore executive power is also given to it. And then we have an advisory, if there is something to deal with the promoting of a real estate sector and some changes is required to be done, naturally RERA can recommend to the state government or to the central government to bring changes in the act. And last is regulatory, as I said, to come out with the required regulations and then punish the wrongdoer. And this is how the functions of RERA. Now, responsibility of the promoter, yes, registration of RERA, declaration by the promoter that he will use the money for the purpose for which it has been taken. He will give the declaration that the title is very much clear. 70% he will deposit in a separate account, no ads without registration. And the last is, the promoter cannot give a false advertisement. If there is no swimming pool, he cannot sell. So the advertisement need to have the registration number of RERA along with the website address of the RERA where the project is registered, and thereafter only he can sell. So this way the promoter is, in the layman language, means builder. Now we have seen the working of MOFA, and if you have to look at the working of RERA, of course there is a real estate regulatory authority, there is appellate authority, competent authority, and compliance is done. Now again, silent feature, yes, there is a state government who are considered to be the appropriate government for appointing a regulator. Union territory for the central government will be the appropriate government. Every real estate project henceforward, that is from 1st May 2017, all new projects as well as ongoing projects where there is no OC has to be registered, real estate agent has to be registered. The most important is disclosure. Under section 4, now section 3 is about registration, section 4 is talking about disclosure. So the promoter has to disclose the last 5 years, which are the projects he has undertaken, whether what was the committed date, whether he has complied, is there any OC pending, all completed project he has to give. Similarly, ongoing projects, what was the agreed date, all the details of that statutory approval has to be given, land status has to be given, he has to take the insurance of the title as and when it comes, notified by the government. And then of course, right now, land title insurance has not come, neither the state government has notified. As and when the state government or the central government notifies about the taking the insurance of the title, that also need to be taken. As far as building insurance is concerned, yes, they need to be taken as per under section 16. Then all the contractual obligation need to be disclosed on the website with whom they have done. And obligation of the promoters, when we talk about section 11 to section 18, is the obligation of the promoter. The moment I say obligation under the statute. And if you don't comply with this, the penalties can be as maximum as 10% of the estimated cost of the project, or it can be 5% also. But depending on the grievances, if you have got a false information, the penalty could be 5%. So in detail, Devang will take. Now coming to the obligation, first section 3 is talking about what is known as registration of a project. Every project before sale has to be registered. Section 4 talking about disclosure. All the information has to be disclosed related to the project as well as its past records. And section 4 also talking about giving a declaration about having a separate designated account wherein 70% has to be done. Section 5 is talking about granting of registration. There is a difference between licensing and registration. There is a difference between approval and registration. Here there is no licensing, absolutely no licensing. What is happening is competent authority, that is a municipal corporation or the planning approval authority, will give the approval. Only after getting the approval, thereafter when the promoter decides that I want to sell, all the details of the land as well as the approval has to be uploaded and register the project, saying that now I want to. There is nothing called licensing. It is only disclosing to the public at large, and before disclosing to the public at large, disclose it to the regulatory authority. Regulatory authority gets satisfied. Thereafter, he is given a registration, that is under section 5, where he is given a password and login, wherein he can upload all the information which is he has submitted under section 4. Then section 6 talks about extension of the registration. The real estate project is always registered for a particular period. So within that period, the real estate regulatory authority, whatever period you are disclosing, within that period, it has to be completed. In case that is not completed, then before the expiry of the 3 months, a promoter need to make an application to the real estate regulatory authority, and thereafter, if the reasons are good enough, the real estate regulatory authority may give maximum 1 year extension. It could be lesser than that, and he can also put various conditions. So this way, if the extension is not given, the registration gets lapsed, and the moment registration gets lapsed, section 7 comes into effect. What is section 7? It can be the what is known as, of course, the section 7 where the registration also can be cancelled. Now registration can be cancelled on the basis of the suo motu, that is the promoter, that real estate regulatory authority himself calls for the information, giving a show cause notice, and if he has done some untrade or illegal practices, malpractices or unfair trade practices, he will be given a show cause notice, called for this, and of course registration can be cancelled. Secondly, it can be revoked, and if it is to be revoked, even the competent authority can give the complaint. Who is competent authority? None other than the planning authority, municipality or gram panchayat or a SIDCO or whoever, SRA, whoever gives the approval, they can complain saying that illegal construction is going on, and therefore the registration has to be cancelled. Third most important, this, even the customer on the basis of the complaint, they can do. So this way, if the third is of course when the period is over. So these are the places where the registration gets cancelled or revoked. Then section 8 comes into effect. If the registration is cancelled, that is where the major problem arises. Here section 8 talks about obligation of the real estate regulatory authority, and this is what is fearing almost all the developers. Here is the obligation of the real estate regulatory authority to take over the project, and after taking over the project, what the compensation will be given to the promoter is nowhere mentioned. Nothing will be paid, and thereafter that project will be handed over to the association of allottee. That means the allottees will form an association. The entire project will be handed over to the association allottee, and who will in turn develop the project. So the promoter loses all right, title, interest in entire land as well as the project. And therefore, and it is talking about the obligation of the real estate regulatory authority. That means real estate regulatory authority has no choice. And therefore, the promoters are very scared about RERA. Because if the registration is cancelled, or it is revoked, or it is lapsed, regulatory authority will take over the project and it will be handed over to the association authority, and the 70% money which is in the separate designated account and it is remained unused, then that account will be frozen and the money will be transferred to the association of authority or the competent authority or any other method as the regulatory authority may decide for the purpose of completing the project. So this way section 3 to section 8 is talking about registration. Then section 9 and 10 is nothing but it is related to registration of a real estate agent, and section 10 is talking about functions and duties of the real estate agent, which means he has to be honest, he cannot disclose more than what has been allowed to be disclosed, and he has to sell only registered project. That's it. Now comes to the approved plan. He has to, now we are talking about section 11. Section 11 is talking about promoter's duties. Once he gets the login and password, then he has to upload all the information about that project, including the what is known as agreement for sale, allotment letter, conveyance deed. Now the conveyance deed, we are contemplating 3 conveyance deed. Now what are the 3 conveyance deed? The first conveyance deed is known as a sale deed. So once you sell the flat, when you take a booking amount, you make an allotment letter. Once you reach more than 10%, you have to register an agreement under section 13. So that is called agreement for sale. The third document which you have to give to the customer at the time of possession is known as sale deed. Because all the obligation of the customer is over and you have completed the project, you have issued the OC, and therefore you have to enter into a sale deed with the customer. So this is contemplated under section 17 of RERA. The next is, there is another conveyance deed which is talking about conveying the common area, that is about the land and the common area and the entire building of the common area to the association of authority, that is nothing but a society. And the third conveyance deed which is to be done is about handing over of the RG, that is playground or amenity area or the road, DP, all this which is required under the DP or town planning, which is to be given to the competent authority, that also need to be handed over. And if you need to enter into any agreement to that effect, conveyance deed, that also need to be done. So this way section 17 provides for 3 type of conveyance deed which has to be done within 3 months from the date of receiving the occupation certificate. So now come to the section 11. As I said, all the disclosure has to be done, including last 5 years record. And then comes 12. When I talk about 12, section 12 talks about he cannot advertise, give the false advertisement, and if he does it, of course he is liable, that promoter is liable for the damages. So the damages will be decided by the adjudicating officer. Section 13 talks about more than 10% money. If you are receiving, you have to register the agreement. You cannot receive more than 10% unless until agreement for sale is registered. And that agreement for sale has to be in a specific format. The format is also given under RERA rules. Next, section 14 talks about consent. What we said is he has to adhere to the approved plan and project specifications. If he wants to change the project specification or the plan which has been registered with the RERA based on which it has been sold, in that case he has to take 2/3 allottee's consent. Without taking consent, he cannot make any changes. And therefore, if he does it, actually he is liable for what is known as compensation. So this way section 14 talks about. And of course his project may be cancelled if the regulatory authority wants to cancel it. Next is section 15, which is talking about he cannot hand over the project to the new guy unless until 2/3 allottee agrees. And most important also, the promoter cannot give to the third party unless until the regulatory authority also gives the consent. That means there is a consent of 2/3 allottee plus regulatory authority consent if he has to sell the project to outsider if he is not able to do it. Under section 14, I just forgot about the consent. Yes, even if there is a defect in the workmanship, that means the project, if he has completed, handed over from the date of possession, if there is any defect in the structural damages or any workmanship, then next 5 years he has to make good the loss. So that way, section 14 also talks about defect liability. Section 15 talks about, as I said, handing over the project. Section 16 talks about the insurance. All type of insurance has to be taken. In addition to that, as and when the appropriate government or the central government notifies about the building insurance and the title insurance, he has to take it, and thereafter that insurance document, including after making all the payment, should be handed over to the association of allotee. Section 16 is about insurance. 17 is about the conveyance, which I just discussed. 3 types of conveyance: sale deed to the individual, common area to the society, and third is about the amenity area to the competent authority. The next is 18. This is a draconian law, once again, very dangerous law, section for the promoter. What it says? It says that the promoter has to hand over the possession of the building the day he has specified in the agreement. If he has specified that 31st December 2022 is my date of delivery, he has to deliver with OC. In case he is not able to do, nobody can stop, he has to pay the interest. Now the question arises, interest has to be paid. That means it's compulsory, nobody can stop, even Narendra Modi or even Rashtrapati cannot stop, because it is an act of parliament, it is an automatic. That means interest, if the customer wants to continue in the project, then he has to get the interest. What is the rate of interest? As far as MahaRERA is concerned, interest will be State Bank of India maximum lending rate plus 2% is the interest payable on all the money that has been paid by the allotee till he hands over the possession. That is one. And it has been it should be paid every month. And further, if the allotee also wants to decide that I want to additional compensation, absolutely he can go to the adjudicating officer, get the compensation. Now the people may say, okay, he is getting interest. What is the compensation? What type of compensation you are talking about? Compensation could be because he was told that he will, or the allotee was told that he will be given the possession on a particular date. He has not given. Now I have to hire another rental premises. No doubt interest you are paying for my meeting my investment or my what is called as the interest on the loan. But what about my alternative accommodation? So therefore the alternative accommodation compensation can be claimed in the form of rent. Now it is also possible that an allotee may say, I don't believe you now, because in the last 3 years you are supposed to give, you have, instead of completing entire building, even you have not put a plinth, or you have put hardly half of the building. Now you may take another 3 years. What I will do with the interest? What I will do with my what is known as rent? So I don't want compensation. I want my money back. In that case, the entire money along with the interest from the day of making the payment till the cancellation, entire money along with the interest is payable. Now the question arises, is it that sufficient? The answer is no. The interest is SBI plus 2%. That is confirmed. Now the question arises, yes, it is not sufficient. Because I booked about 3 years back. At that time in Vasai it was 3,000 rupees rate. But after 3 years, I am supposed to get the possession, but the flat cost has gone up to 7,000. Now the rates have gone up. So if today I have to buy the same land or the same flat, naturally I have to pay 7,000. So that means I have lost 4,000 rupees per square foot. So this 4,000 multiplied by, even if he has purchased 1,000 square foot, which means another 40 lakh rupees will have to be paid as a compensation. So this way, not only the interest, even the compensation has to be paid in case the person wants to withdraw. It doesn't mean that he has no other remedy. He can further go for any other remedy that he wants to avail. So without prejudice to any other remedy, it can be. Now, so one, if he wants to continue, one he wants to withdraw. The next is again, under section 18 again, one more, which is talking about, let us say, there is a defective title. Possible, there is a defective title. In case there is a defective title, in that case, what happens is that some compensation may have to be paid after 20 years, 30 years. In that case, irrespective of the law of limitation, there is no law of limitation, irrespective of any time limit, without any time limit, irrespective of the law of limitation, without any law of limitation, the promoter will have to make the compensation as and when claimed if there is a defective title. So that means the promoter is liable for the defective title without any law of limitation. So he will have to make good. Therefore, there is an insurance which has been provided. Now that there is no insurance company, so the promoter may not be liable. Now the next is again, there can be any other compensation. So if customer wants that some other, because a lot of defective advertisement, or he has promised something which he has not given. So all these compensation can be claimed under section 18 by going to the adjudicating officer. The next section is all section 11 to 18 is the obligation, statutory obligation of the promoter. Now let us come to section 19, which is talking about allottees. So section 11 also talks about once you sell more than 50%, you have to register the society. So that means now, even after selling more than 51% of the flats, booking the flat, you are required to register the society. Which means now societies will supervise the work of the builder. Then we were talking about obligation, statutory obligation. All these are the statutory obligation. He has to enter into agreement, give the OC and give collections. These are the different types of association which he can form. Either society, federation, company, condominium under the respective act for the purpose of managing the affairs. Then promoter has to give the title. As I said, the promoter shall execute a registered conveyance deed in favor of allottee first. Along with, that means sale deed. In MOFA, there was no concept of sale deed. There it was saying, section 11 I was talking about, once you register a society, within 4 months from the date of that, you convey the land, title, building, everything to the society. There was no contemplation of the individual sale deed. So therefore, under RERA, now there will be individual sale deed. So maybe there is no additional stamp duty, it could be hardly 100 rupees, but one has to execute a different sale deed. Then along with the undivided proportionate title of common areas to the association of allotee. When we talk about common area includes land, building, other areas. And or the competent authority as the case may be. If there is a RG and all, you have to give it to the, or playground and other things which is required to be given to the competent authority, then you have to give it to the competent authority. Within 3 months from the date of issue of occupation certificate. The society has to be made within 3 months. Then obligation of the allotee, section 19, they have to make the regular payment, that's one. Then their regulatory, promoter, allotee has another right under section 19 to ask for the stage wise work progress. And then if they don't make the payment, yes, naturally, the interest can be levied by the promoter. The interest is again SBI maximum marginal lending rate plus 2%. The same interest what has to be paid to the allotee will have to pay the same interest if there is a delay. The next, yes, naturally, if because of the allotee some damages is occurred to the promoter can claim for the damages. The next most important is that the allottees required to join the societies, they required to give all the documents as may be required for the purpose of conveyance, and if the payment is not made after entering into an agreement, and thereafter the promoter can cancel the agreement. But the terms of cancellation of the agreement is mentioned in the agreement for sale. That could be any reason, but at least minimum 15 days registered post notice has to be given. Thereafter, the cancelled flat, the promoter can also charge the cancellation charges. He need not pay the interest on the amount paid. Cancellation charges could be 10%, 15%, 20% as may be decided by the promoter, which is put in the agreement for sale. The next most important, one has to understand that once it is cancelled, the allotee has a right, of course, to go to the Real Estate Regulatory Authority and Appellate Tribunal, and matter will be decided. Till such time, of course, he may not be able to sell, but definitely promoter can cancel the agreement. So this is about the conveyance. The conveyance, if it is individual, of course, it can be 100%, and in a case of layout, it can be proportionate. Now this is what the silent feature. Again, the RERA will coordinate the efforts with the various things, render the advice to appropriate government, establish dispute redressal mechanism. The central government will make the act, state will have the powers to make, regulatory authority will do the regulations, and central government and the state government may come out with the regulation. Dispute redressal mechanism, in detail you will come to know, adjudicating officer, regulatory authority and real estate appellate tribunal, all will have to decide the matter, and the civil court is barred, and again consumer court will continue. Penal provisions are there, and this is what I am talking about. The Article 246, Schedule 7 talks about constitutional framework, wherein transfer of property other than agriculture land is in the concurrent list, and because it is in the concurrent list, therefore the central government could make the law. Contracts including partnerships, special type of contract, this is a special type of contracts not relating to agriculture, and then of course dispute redressable other than Supreme Court is with the concurrent list, therefore this has been made. Now the last slide, if I have to tell you that the real estate regulatory authority is not another planning authority. It is not a licensing authority. It is only an agency which will collect all the information from the promoter related to the land, related to the approval, and works as a screening agency. And that screening agency, once it is satisfied, will allow the registration of the project, and thereafter only the promoter can sell the flats. And the flat purchase, of course, it is there. So earlier in MOFA, there was an approval authority, flat purchaser, but there was no screening agency. In the real estate regulatory authority, we have a screening agency called RERA. Registration under section 4, as I said, yes, all the projects need registration as far as new project is concerned, and where there is a OC has been issued, not issued, they have to register within 3 months. And what is exempted is all the projects where the OC is granted, of course before the commencement of the act, and area does not exceed 500 square meter. If it is less than 500 square meter or less than 8 units, you don't require registration. And where there is no sale, but entire thing is only repairing or reconstruction, then that need not be registered. Next, section 4 talks about disclosure. Disclosure, you have to talk about land, size, you have to talk about phases, you have to talk about facilities, you have to talk about each approval phases, declaration, and as and when it gets on quarterly basis, you have to update with the photographs as to what is the progress. And quarterly basis, what is the estimated cost that you have incurred. Initially, you have to give the complete estimated cost. And then of course title is clear, non-encumbrance certificate has to be given, all the specimen of conveyance deed, allotment letter, agreement for sale, project terms and condition, how it will be completed, what is the schedule, then 70% will be kept in the account. And section 7 talks about revocation, where on the basis of the complaint by anybody or suo moto, or on the basis of the complaint by the regulatory authority or competent authority, it can be cancelled. Consequence of revocation, section 8, which I already discussed, that is about the debarring the promoter from accessing the website, debarring him as a promoter, and then he cannot continue with the project. Project will be taken over by the real estate regulatory authority. It will be decided by them whether to give competent authority or to give it to the associate allottee. But the right of refusal, first right of refusal is with the allottees, and they will be declared as a defaulter. Their photographs will be disclosed and displayed across India, not in Maharashtra RERA, but it will be informed to other real estate regulatory across India, that is all 7 union territories and 29 states, and that is how that is going to be dangerous. And last is the 70% account, where the people money is kept, which will be used only for the purpose of land cost and construction cost. If there is any money, it will be frozen and all money will be handed over to the new. So this is how the 10 chapters, 92 sections, I have dealt with up to section 19. So now you have other 6 chapters which has to be dealt with. I have dealt with chapter number 1, preliminary, which has commenced from 1st May 2017, and I discussed with the real estate regulatory authority registration, project registration, all development project has to be registered. Functions and duties of promoter 11 to 18 I have described in detail. Rights of duties I have discussed, and that is what is my things. And then there are 5 rules which has been published by the state government. This is section 3 to 18. If you have to look at it, this is how it can be put. And rights and duties of the allottees, section 19, obtain information related to the project, no stage-wise development, claim the refund in case there is a, and duties is to pay the proportionate share of the society formation charges and other thing. This is with the CM, with I had discussion about housing projects. This is with Pratibha Tai Patil. The way I am talking to you, I had an opportunity to even discuss with the president, the then Pratibha Tai Patil, where I had written some books which I had presented. And this is Ashok Chavan, with whom I had, I was felicitated, and Prithviraj Chavan, and this is Shanmukananda, where I could deliver, and my book was released by the then, of course, CM and Deputy CM, and this is Gautam Chatterjee, who is the regulatory authority, Sitaram Kunte, who is the municipal commissioner at that time, and this is my book which was given. This is Swadhin Kshatriya, who retired as a chief secretary, and now he is the commissioner for what is known as Swadhin Kshatriya is now Right to Public Service Act 2015. He is now designated as the Commissioner for Right to Public Service. So if the way we have a right to information, RTI, so we have a RTS now, Right to Service. So he is the Commissioner for RTS and he is retired as the Chief Secretary. Thank you very much. So now there is enough slides, but the time is the constraint. I have taken exactly, I suppose, 1 hour or maybe a little more than that. But you will have to, if you have got 1 or 2 questions, I can take only 1 or 2, not beyond that. Because I have to leave. I got 8 o'clock train to go to Akola, so Dadar. So I have to reach, yeah.
Half of the societies in Mumbai, which are very old and doesn't have OC, do they have to register with RERA?
This has been asked as a FAQ. Real Estate Regulatory Authority has given answer in the FAQ saying that if the project is complete, people are staying there, there is nothing to be sold. If all 3 conditions are met, they should not register the project or they may not register the project. He used the word, they need not register the project. But the law says otherwise. 1. Secondly, when I met him, discussed with him, he said, fine, if the existing society people come and complain to me, saying that the promoter has not given me the OC, and therefore, you levy him the penalty, I will do one thing. I will ask that complainant first to vacate the flat. Because he is an allottee who is not supposed to occupy the flat which is under RERA, which is not having OC. So let him vacate the flat first and then come to me saying that yes, I have not occupied, building is not completed, and thereafter I will punish the promoter. So is it practical? The answer is no. Therefore, we had as an association said, represented before MahaRERA saying that we have to find out the solution. So he said, what is the solution? The solution is, then let us come out with the amnesty scheme for those projects where there is no OC. So he has already recommended to the Maharashtra government for the purpose of coming out with the amnesty scheme. And let me tell you one step ahead, Ajay Mehta, who is the commissioner, also has recommended amnesty scheme for OC, which was already there in 2004 and 5. Same has been done, and now the projects which are not having a OC, which the members are occupying before 1st January 2012, all those projects will be covered under amnesty scheme, and the nominal penalty will be levied and it will be regularized. So this way, and after getting deemed conveyance. Now I said for the deemed conveyance also, unless if you have to go for amnesty scheme also, I need to have the land title. To have a land title, now I have to go for deemed conveyance, or otherwise deemed conveyance also needs OC. So I don't have the OC. Even MahaRERA, on the basis of our recommendation, has recommended to the government to exempt the condition of OC for deemed conveyance. So therefore, they will get a deemed conveyance and thereafter without OC, and thereafter they can go for the amnesty scheme. So this way the process is going on. So but I am not saying that you don't complain, but if you ask me legally, yes, where there is no OC, it's a incomplete building, and because it's an incomplete building, the OC has to be obtained. But what happens is, the promoter also, the moment you say, promoter will say, I want to take a OC, but these people have encroached the balcony, you have done this. So I am opening a Pandora box, and these are all the liability which is created much before the RERA could come into effect. So I may also advise them to go under MOFA. So the RERA I am not going to cover because you are illegally occupied. So both of you are wrong. So therefore RERA I don't want to take. I will take the projects where the flats has to be sold and where they are not occupied and the OC is pending. These are the projects that he is taking up. I think I have answered your question. Yeah. Yeah.
I would like to know if a project which has been sold 30 to 40% and say by 1st August the developer doesn't register for RERA. So how can the
Very simple, very simple. There is a maharera.helpdesk@gmail.com. You send an email that will be treated as your sourced information. Once it becomes a sourced information, they will send their officer concerned. They have got about 50 officers already recruited, and there is enough sourced information they have started collecting, and they are more concerned that many of the developers are not registering for one or the other reason. And once they get this type of complaint and the sourced information, they will be very happy and they can levy 10% penalty, which the advocate Devang will tell you. So therefore, it's earnest request and the advice to every developer that if the project they have sold even one flat, and then they should get registered. The second advice, if they are not having a plan, still they have booked the flat, given the allotment, and under MOFA they were not supposed to do, still they have done, then they should cancel that agreement. They have to call for the allotment letter back, refund the money, square the account, and then do it. Otherwise, they may lend into something called MahaRERA will only say that this does not come under me because that project is not registered. If the complaint comes, they will refer this to the police. The police will then take the cognizance because MahaRERA only can refer to the police. So the matter will go to the police, it will become a cheating and fraud. Because under MOFA also you are not supposed to sell unless until you get the plan passed. Now there is a MahaRERA where you complain, they will refer the matter to police. Okay, thank you very much. Thank you.